Okay, so Mental Hygiene Law 10.07 continued. Within 60 days after the court determines pursuant to sub K 10.06 that there is probable cause to believe the respondent requires civil management, the court shall conduct a jury trial to determine whether the respondent is a detained sex offender who suffers from a mental abnormality. So the number one question the jury is deciding here is an issue of fact, and it's whether or not the respondent is a detained sex offender who suffers from a mental abnormality. Now, this is where it gets a little bit confusing. It says the provisions of Article 41 of the CPLR shall apply to the formation and conduct of the jury trial. Okay, except that provisions of the following CPL sections govern to the extent that they are not inconsistent therewith. Now, Section 270.05 is the first one. The very first line of 270.05 is that there are 12 jurors. 270.10 describes a challenge to the panel. 270.15 is voir dire generally. It begins with saying that the names of not less than 12 jurors shall be selected and seated in the jury box. 270.20 describes the challenge for cause. Subdivision 1 of 270.25 is just the definition of a peremptory challenge. And then 270.35 is about replacing a juror, and it says that the respondent doesn't have to consent in this section because it says, except for the provision requiring consent of the replacement of a discharged juror with an alternate. So, each side shall have 10 peremptory challenges for the regular jurors and 2 for each alternate to be selected. The right to jury trial may be waived, and upon such waiver, the court will have a civil jury trial. Non-jury trial. All right? So basically, that is what this is saying. So even though it does say the CPLR, the provisions of those rules apply to the formation and conduct of a jury trial under this section, the provisions of CPL 270.05, 10, 15, 20, sub 1 of 270.25 and sub 1 of 270.35 apply, and that is specifically talking about the number of jurors.